Well, hello, my lovely fellow nerds. Happy Labor Day. It's been quite a while since I've said hello personally, so I thought that a proper update was in order before getting into today's opinion, Groff v. DeJoy. It's been quite an eventful summer, to say the least, here in the Getchell household. My husband and I and our 3 cats packed up our home in preparation for a long cross-country move back to Washington, D.C. At the same time, we ushered our daughter off to San Francisco for graduate school. However, at the 11th hour, fate would have it that we would be given the opportunity to stay in San Diego, and with our baby girl a short flight or a long drive away from San Diego, we took it. And so after packing everything up, we are now unpacking it all again, but very happy to be staying here in America's finest city. So that's what's been going on during my short opinion reading hiatus. That and also reading the Trump indictments together in several bonus episodes that I squeezed in over the past month. I hope that you all had a great summer, hopefully less eventful than mine was. It is hard to believe that it's already fall and it's time to get back into the swing of things for those of you on an academic calendar anyway. And for those of you who are excited for a new term of cases to be heard by the Supreme Court, the new term is set to begin, as always, on the first Monday in October, which falls on October 2nd this year, which is less than a month away. But before we even begin to think about that, I'd like to finish reading the dozen or so cases that I missed from last term before we kick off a new season here on What SCOTUS Wrote Us. Besides, if this term is anything like the last term, we won't be seeing any new decisions come our way until the new year anyway. I am planning on putting together a sneak peek episode to discuss what cases are ahead of us before that happens. As a side note, we have gained quite a few listeners over the summer, and I want to welcome you all to the podcast, whether you're an attorney, a student, or a citizen who wants to stay informed of what's going on in our third branch of our republic, or one of our international friends. Welcome, one and all. Feel free to reach out to request an opinion to be read on the show, provide feedback, or just to say hi at whatscotuswroteus.com. That's whatscotuswroteus.com. Okay, enough chit-chat. It's time to get to the reason that we are all here. Without further ado, I give you the opinion of the court in Groff v. DeJoy. Enjoy. Justice Alito delivered the opinion for a unanimous court. Title VII of the Civil Rights Act of 1964 requires employers to accommodate the religious practice of their employees, unless doing so would impose an undue hardship on the conduct of the employer's business. Based on a line in this court's decision in Trans World Airlines, Inc. v. Hardison, 1977, many lower courts, including the Third Circuit below, have interpreted undue hardship to mean any effort or cost that is more than de minimis. In this case, however, both parties, the plaintiff petitioner Gerald Groff and the defendant respondent, the Postmaster General, represented by the Solicitor General, agree that the de minimis reading of Hardison is a mistake. With the benefit of thorough briefing and oral argument, we today clarify what Title VII requires. Part 1. Gerald Groff is an evangelical Christian who believes, for religious reasons, that Sunday should be devoted to worship and rest, not secular labor and the transportation of worldly goods. In 2012, Groff began his employment with the United States Postal Service, USPS, which has more than 600,000 employees. He became a rural carrier associate, a job that required him to assist regular carriers in the delivery of mail. When he took the position, it generally did not involve Sunday work, but within a few years, that changed. In 2013, USPS entered into an agreement with Amazon to begin facilitating Sunday deliveries, and in 2016, USPS signed a Memorandum of Understanding with the relevant union, the National Rural Letter Carriers Association, that set out how Sunday and holiday parcel delivery would be handled. During a 2-month peak season, each post office would use its own staff to deliver packages. At all other times, Sunday and holiday deliveries would be carried out by employees, including rural carrier associates like Groff, working from a regional hub. For Quarryville, Pennsylvania, where Groff was originally stationed, the regional hub was the Lancaster Annex. The memorandum specifies the order in which USPS employees are to be called on for Sunday work outside the peak season. First in line are each hub's assistant rural carriers, part-time employees who are assigned to the hub and cover only Sundays and holidays. Second are any volunteers from the geographic area who are assigned on a rotating basis. And third are all other carriers who are compelled to do the work on a rotating basis. Groff fell into this third category, and after the Memorandum of Understanding was adopted, he was told that he would be required to work on Sunday. He then sought and received a transfer to Holtwood, a small rural USPS station that had only 7 employees and that at the time did not make Sunday deliveries. But in March 2017, Amazon deliveries began there as well. With Groff unwilling to work on Sundays, USPS made other arrangements. During the peak season, Sunday deliveries that would have otherwise been performed by Groff were carried out by the rest of the Holtwood staff, including the postmaster, whose job ordinarily does not involve delivering mail. During other months, Groff's Sunday assignments were redistributed to other carriers assigned to the regional hub. Throughout this time, Groff continued to receive progressive discipline for failing to work on Sundays. Finally, in January 2019, he resigned. A few months later, Groff sued under Title VII, asserting that USPS could have accommodated his Sunday Sabbath practice without undue hardship on the conduct of USPS's business. The district court granted summary judgment to USPS, and the Third Circuit affirmed. The panel majority felt that it was bound by the ruling in Hardison, which it construed to mean that requiring an employer to bear more than a de minimis cost to provide a religious accommodation is an undue hardship. Under circuit precedent, the panel observed, this was not a difficult threshold to pass, and it held that this low standard was met in this case. Exempting Groff from Sunday work, the panel found, had imposed on his coworkers, disrupted the workplace and workflow, and diminished employee morale. Judge Hardiman dissented, concluding that adverse effects on USPS employees in Lancaster or Holtwood did not alone suffice to show the needed hardship on the employer's business. We granted Groff's ensuing petition for a writ of certiorari. Part 2. Because this case presents our first opportunity in nearly 50 years to explain the contours of Hardison, we begin by recounting the legal backdrop to that case, including the development of the Title VII provision barring religious discrimination and the Equal Employment Opportunity Commission, EEOC's, regulations and guidance regarding that prohibition. We then summarize how the Hardison case progressed to final decision, and finally, we discuss how courts and the EEOC have understood its significance. This background helps to explain the clarifications we offer today. Section A. Since its passage, Title VII of the Civil Rights Act of 1964 has made it unlawful for covered employers to fail or refuse to hire or to discharge any individual or otherwise to discriminate against any individual with respect to compensation, terms, conditions, or privileges of employment because of such individual's religion. As originally enacted, Title VII did not spell out what it meant by discrimination because of religion, but shortly after the statute's passage, the EEOC interpreted that provision to mean that employers were sometimes required to accommodate the reasonable religious needs of employees. After some tinkering, the EEOC settled on a formulation that obligated employers to make reasonable accommodations to the religious needs of employees whenever that would not work an undue hardship on the conduct of the employer's business. Between 1968 and 1972, the EEOC elaborated on its understanding of undue hardship in a long line of decisions addressing a variety of policies. Those decisions addressed many accommodation issues that still arise frequently today, including the wearing of religious garb and time off from work to attend religious obligations. EEOC decisions did not settle the question of undue hardship. In 1970, the Sixth Circuit held, in a Sabbath case, that Title VII, as then written, did not require an employer to accede to or accommodate religious practice because that would raise grave Establishment Clause questions. See Dewey v. Reynolds Metals Company, 1971. This court granted certiorari, but then affirmed by an evenly divided vote. Responding to Dewey and another decision rejecting any duty to accommodate an employee's observance of the Sabbath, Congress amended Title VII in 1972. Tracking the EEOC's regulatory language, Congress provided that the term religion includes all aspects of religious observance and practice, as well as belief, unless an employer demonstrates that he is unable to reasonably accommodate to an employee's or prospective employee's religious observance or practice without undue hardship on the conduct of the employer's business. Section B. The Hardison case concerned a dispute that arose during the interval between the issuance of the EEOC's undue hardship regulation and the 1972 amendment to Title VII. In 1967, Larry Hardison was hired as a clerk at the stores department in the Kansas City base of Trans World Airlines, TWA. The stores department was responsible for providing parts needed to repair and maintain aircraft. See Hardison v. Trans World Airlines, 1974. It played an essential role and operated 24 hours per day, 365 days per year. After taking this job, Hardison underwent a religious conversion. He began to observe the Sabbath day by absenting himself from work from sunset on Friday to sunset on Saturday, and this conflicted with his work schedule. The problem was solved for a time when Hardison, who worked in Building 1, switched to the night shift, but it resurfaced when he sought and obtained a transfer to the day shift in Building 2 so that he could spend evenings with his wife. In that new building, he did not have enough seniority to avoid work during his Sabbath. Attempts at accommodation failed, and he was eventually discharged on grounds of insubordination. Hardison sued TWA and his union, the International Association of Machinists and Aerospace Workers, IAM. The Eighth Circuit found that reasonable accommodations were available, and it rejected the defendant's Establishment Clause arguments. Both TWA and IAM then filed petitions for certiorari, with TWA's lead petition asking this court to decide whether the 1972 amendment of Title VII violated the Establishment Clause as applied in the decision below. particularly insofar as that decision had approved an accommodation that allegedly overrode seniority rights granted by the relevant collective bargaining agreement. The court granted both petitions. When the court took that action, all counsel had good reason to expect that the Establishment Clause would figure prominently in the court's analysis. As noted above, in June 1971, the court, by an equally divided vote, had affirmed the Sixth Circuit's decision in Dewey, which had heavily relied on Establishment Clause avoidance to reject the interpretation of Title VII set out in the EEOC's Reasonable Accommodation Guidelines. Just over 3 weeks later, the court had handed down its now abrogated decision in Lemon v. Kurtzman, 1971, which adopted a test under which any law whose principal or primary effect was to advance religion was unconstitutional. Because it could be argued that granting a special accommodation to a religious practice had just such a purpose and effect, some thought that Lemon posed a serious problem for the 1972 amendment of Title VII. And shortly before review was granted in Hardison, the court had announced that the justices were evenly divided in a case that challenged the 1972 amendment as a violation of the Establishment Clause. See Parker Seal Company v. Cummins, 1976. Against this backdrop, both TWA and IAM challenged the constitutionality of requiring any accommodation for religious practice. The summary of argument in TWA's brief began with this categorical assertion: the religious accommodation requirement of Title VII violates the Establishment Clause of the First Amendment. Applying the three-part Lemon test, TWA argued that any such accommodation has the primary purpose and effect of advancing religion and entails pervasive government entanglement in religious issues. The union's brief made a similar argument, but stressed the special status of seniority rights under Title VII. Despite the prominence of the Establishment Clause in the briefs submitted by the parties and their amici, constitutional concerns played no on-stage role in the court's opinion, which focused instead on seniority rights. The opinion stated that the principal issue on which TWA and the union came to this court was whether Title VII requires an employer and a union who have agreed on a seniority system to deprive senior employees of their seniority rights in order to accommodate a junior employee's religious practices. The court held that Title VII imposed no such requirement. This conclusion, the court found, was supported by the fact that seniority systems are afforded special treatment under Title VII itself. It noted that Title VII expressly provides special protection for bona fide seniority systems, and it cited precedent reading the statute to make clear that the routine application of a bona fide seniority system is not unlawful under Title VII. Invoking these authorities, the court found that the statute did not require an accommodation that involuntarily deprived employees of seniority rights. Applying this interpretation of Title VII and disagreeing with the Eighth Circuit's evaluation of the factual record, the court identified no way in which TWA, without violating seniority rights, could have feasibly accommodated Hardison's request for an exemption from work on his Sabbath. The court found that not enough coworkers were willing to take Hardison's shift voluntarily, that compelling them to do so would have violated their seniority rights, and that leaving the store's department short-handed would have adversely affected its essential mission. The court also rejected two other options offered in Justice Marshall's dissent. One, paying other workers overtime wages to induce them to work on Saturdays, and making up for that increased cost by requiring Hardison to work overtime for regular wages at other times, and 2, forcing TWA to pay overtime for Saturday work for 3 months, after which, the dissent thought, Hardison could transfer back to the night shift in Building 1. The court dismissed both of these options as not feasible, but it provided no explanation for its evaluation of the first. In dissent, Justice Marshall suggested one possible reason, that the collective bargaining agreement might have disallowed Hardison's working overtime for regular wages, but the majority did not embrace that explanation. As for the second, the court disputed the dissent's conclusion that Hardison, if he moved back to Building 1, would have had enough seniority to choose to work the night shift. That latter disagreement was key. The dissent thought that Hardison could have resumed the night shift in Building 1 after just 3 months, and it therefore calculated that it would have cost TWA to pay other workers overtime wages on Saturdays for that finite period of time. According to that calculation, TWA's added expense for 3 months would have been $150, about $1,250 in $2,022. But the court doubted that Hardison could have regained the seniority rights he had enjoyed in Building 1 prior to his transfer, and if that were true, TWA would have been required to pay other workers overtime for Saturday work indefinitely. Even under Justice Marshall's math, that would have worked out to $600 per year at the time, or roughly $5,000 per year today. In the briefs and at argument, little space was devoted to the question of determining when increased costs amount to an undue hardship under the statute, but a single but oft-quoted sentence in the opinion of the court, if taken literally, suggested that even a pittance might be too much for an employer to be forced to endure. The line read as follows: to require TWA to bear more than a de minimis cost in order to give Hardison Saturdays off is an undue hardship. Although this line would later be viewed by many lower courts as the authoritative interpretation of the statutory term undue hardship, it is doubtful that it was meant to take on that large role. In responding to Justice Marshall's dissent, the court described the governing standard quite differently, stating 3 times that an accommodation is not required when it entails substantial costs or expenditures. This formulation suggests that an employer may be required to bear costs and make expenditures that are not substantial. Of course, there is a big difference between costs and expenditures that are not substantial and those that are de minimis, which is to say, so very small or trifling that they are not even worth noticing. The court's response to Justice Marshall's estimate of the extra cost that TWA would have been required to foot is also telling. The majority did not argue that Justice Marshall's math produced considerably more than a de minimis cost, as it certainly did. Instead, the court responded that Justice Marshall's calculation involved assumptions that were not feasible under the circumstances and would have produced a different conflict with the seniority rights of other employees. Ultimately, then, it is not clear that any of the possible accommodations would have actually solved Hardison's problem without transgressing seniority rights. The Hardison court was very clear that those rights were off limits. Its guidance on undue hardship in situations not involving seniority rights is much less clear. Section C. Even though Hardison's reference to de minimis was undercut by conflicting language and was fleeting in comparison to its discussion of the principal issue of seniority rights, lower courts have latched on to de minimis as the governing standard. To be sure, as the Solicitor General notes, some lower courts have understood that the protection for religious adherents is greater than more than de minimis might suggest when read in isolation. But a bevy of diverse religious organizations has told this court that the de minimis test has blessed the denial of even minor accommodations in many cases, making it harder for members of minority faiths to enter the job market. The EEOC has also accepted Hardison as prescribing a more than de minimis cost test, but has tried in some ways to soften its impact. It has specifically cautioned, as has the Solicitor General in this case, against extending the phrase to cover such things as the administrative costs involved in reworking schedules, the infrequent or temporary payment of premium wages for a substitute, and voluntary substitutes and swaps when they are not contrary to a bona fide seniority system. Nevertheless, some courts have rejected even the EEOC's gloss on de minimis, and in other cases, courts have rejected accommodations that the EEOC's guidelines consider to be ordinarily required, such as the relaxation of dress codes and coverage for occasional absences. Members of this court have warned that if the de minimis rule represents the holding of Hardison, the decision might have to be reconsidered. Today, the Solicitor General disavows its prior position that Hardison should be overruled, but only on the understanding that Hardison does not compel courts to read the more than de minimis standard literally or in a manner that undermines Hardison's references to substantial cost. With the benefit of comprehensive briefing and oral argument, we agree. Part 3. We hold that showing more than a de minimis cost, as that phrase is used in common parlance, does not suffice to establish undue hardship under Title VII. Hardison cannot be reduced to that one phrase. In describing an employer's undue hardship defense, Hardison referred repeatedly to substantial burdens, and that formulation better explains the decision. We therefore, like the parties, understand Hardison to mean that undue hardship is shown when a burden is substantial in the overall context of an employer's business. This fact-specific inquiry comports with both Hardison and the meaning of undue hardship in ordinary speech. Section A. As we have explained, we do not write on a blank slate in determining what an employer must prove to defend a denial of a religious accommodation, but we think it reasonable to begin with Title VII's text. After all, as we have stressed over and over again in recent years, statutory interpretation must begin with and ultimately heed what a statute actually says. Here, the key statutory term is undue hardship. In common parlance, a hardship is, at a minimum, something hard to bear. Other definitions go further, but under any definition, a hardship is more severe than a mere burden. So even if Title VII said only that an employer need not be made to suffer a hardship, an employer could not escape liability simply by showing that an accommodation would impose some sort of additional costs. Those costs would have to rise to the level of hardship, and adding the modifier undue means that the requisite burden, privation, or adversity must rise to an excessive or unjustifiable level. the government agrees, noting that undue hardship means something greater than hardship. When undue hardship is understood in this way, it means something very different from a burden that is merely more than de minimis, i.e., something that is very small or trifling. So, considering ordinary meaning while taking partisan as a given, we are pointed toward something closer to Hardison's references to substantial additional costs or substantial expenditures. Similarly, while we do not rely on the pre-1972 EEOC decisions described above to define the term, we do observe that these decisions often found that accommodations that entailed substantial costs were required. Nothing in this history plausibly suggests that undue hardship in Title VII should be read to mean anything less than its meaning in ordinary use. In short, no factor discussed by the parties, the ordinary meaning of undue hardship, the EEOC guidelines that Hardison concluded that the 1972 amendment ratified, the use of that term by the EEOC prior to those amendments, and the common use of that term in other statutes, supports reducing Hardison to its more than a de minimis cost line. Section B. In this case, both parties agree that the de minimis test is not right, but they differ slightly in the alternative language they prefer. Groff likes the phrase significant difficulty or expense. The government, disavowing its prior position that Title VII's text requires overruling Hardison, points us to Hardison's repeated references to substantial expenditures or substantial additional costs. We think it is enough to say that an employer must show that the burden of granting an accommodation would result in substantial increased costs in relation to the conduct of its particular business. What matters more than a favored synonym for undue hardship, which is the actual text, is that courts must apply the test in a manner that takes into account all relevant factors in the case at hand, including the particular accommodations at issue and their practical impact in light of the nature, size, and operating cost of an employer. Section C. The main difference between the parties lies in the further steps they would ask us to take in elaborating upon their standards. Groff would not simply borrow the phrase significant difficulty or expense from the Americans with Disabilities Act, ADA, but would have us instruct lower courts to draw upon decades of ADA case law. The government, on the other hand, requests that we opine that the EEOC's construction of Hardison has been basically correct. Both of these suggestions go too far. We have no reservations in saying that a good deal of the EEOC's guidance in this area is sensible and will, in all likelihood, be unaffected by our clarifying decision today. After all, as a public advocate for employees' rights, much of the EEOC's guidance has focused on what should be accommodated. Accordingly, today's clarification may prompt little, if any, change in the agency's guidance explaining why no undue hardship is imposed by temporary costs, voluntary shift swapping, occasional shift swapping, or administrative costs. But it would not be prudent to ratify in toto a body of EEOC interpretation that has not had the benefit of the clarification we adopt today. What is most important is that undue hardship in Title VII means what it says, and courts should resolve whether a hardship would be substantial in the context of an employer's business in the common sense manner that it would use in applying any such test. Section D. The erroneous de minimis interpretation of Hardison may have had the effect of leading courts to pay insufficient attention to what the actual text of Title VII means with regard to several recurring issues. Since we are now brushing away that mistaken view of Hardison's holding, clarification of some of those issues, in line with the parties' agreement in this case, is in order. First, on the second question presented, both parties agree that the language of Title VII requires an assessment of a possible accommodation's effect on the conduct of the employer's business. As the Solicitor General put it, not all impacts on coworkers are relevant, but only coworker impacts that go on to affect the conduct of the business. So an accommodation's effect on coworkers may have ramifications for the conduct of the employer's business, but a court cannot stop its analysis without examining whether that further logical step is shown in a particular case. On this point, the Solicitor General took pains to clarify that some evidence that occasionally is used to show impacts on coworkers is off the table for consideration. Specifically, a coworker's dislike of religious practice and expression in the workplace, or the mere fact of an accommodation, is not cognizable to factor into the undue hardship inquiry. To the extent that this was not previously clear, we agree. An employer who fails to provide an accommodation has a defense only if the hardship is undue, and a hardship that is attributable to employee animosity to a particular religion, to religion in general, or to the very notion of accommodating religious practice, cannot be considered undue. If bias or hostility to a religious practice or a religious accommodation provided a defense to a reasonable accommodation claim, Title VII would be at war with itself. Second, as the Solicitor General's authorities underscore, Title VII requires that an employer reasonably accommodate an employee's practice of religion, not merely that it assess the reasonableness of a particular possible accommodation or accommodations. This distinction matters. Faced with an accommodation request like Groff's, it would not be enough for an employer to conclude that forcing other employees to work overtime would constitute an undue hardship. Consideration of other options, such as voluntary shift swapping, would also be necessary. Part 4. Having clarified the Title VII undue hardship standard, we think it appropriate to leave the context-specific application of that clarified standard to the lower courts in the first instance. The Third Circuit assumed that Hardison prescribed a more than a de minimis cost test, and this may have led the court to dismiss a number of possible accommodations, including those involving the cost of incentive pay or the administrative costs of coordination with other nearby stations with a broader set of employees. Without foreclosing the possibility that USPS will prevail, we think it appropriate to leave it to the lower courts to apply our clarified context-specific standard and to decide whether any further factual development is needed. The judgment of the Court of Appeals is vacated, and the case is remanded for further proceedings consistent with this opinion. It is so ordered. We've come to the end of the opinion. Until next time, thanks for listening to What SCOTUS Wrote Us.